Start over. We need a mic that turns itself on because I don't forget it.
Don't caress it.
I'm leaving fingerprints. Anyway, call to order the special meeting of the Civil Service Commission for Thursday, April 24th, 2025, 5:34. At this time, I have the call to order and Pledge of Allegiance. Mr. Bill has a special.
Monte Piscaresi, great family of Madera, passed away. So I'd like us to do the pledge in memory of Monte and great contributions in all of the Piscaresis to this beautiful county. Right hand over our heart. Ready to begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice. Thank you. God bless you, Monty.
A lot of us in Chowchilla have had a connection with every single one of them, even the ones here in Madera.
Oh,
Thank you. Public comment. This time is made available for comments from the public on matters within the Civil Service Commission's jurisdiction that are not on the agenda. Each speaker will be limited to 3 minutes. Seeing none. Do we have anybody on screen online? Is anybody online? Okay.
They are, but they're not making a comment.
Okay, then we'll move on to regular business and reconvene the hearing. Forget where we were at. You had a witness up?
Yes, the union would like to call its next witness, Courtney Hawkins.
Okay,
But before we do so, I would like to request if we're able to take a short break to make copies of a exhibit that I have here for everyone and that I would like to show this witness.
could have done that 20 minutes ago.
I know.
don't yell at her.
I was
I
soft.
apologize for the delay.
Okay, yes.
Just 1 second. Is this an exhibit that has already been provided to the county?
No, it's not.
Okay, the county would object. The exhibits are supposed to be exchanged by the parties within 10 days of the hearing. And so that's to avoid the surprise exhibits.
And
The
I
county's
take it,
position is that this has been somewhat of a drawn out process and the introduction of surprise exhibits would be inappropriate, and the parties have already exchanged the exhibits in accordance with the civil service rules.
May I respond?
yes.
The county should not be surprised by the exhibit because it is an email correspondence from its own representatives that it should already have in its files. And so this isn't a surprise. They should have it because they sent it themselves to the union and it's directly relevant to the issue.
But if he doesn't see it, how does he know if it's in his file or not?
In whose file?
In
Council's?
the council's file.
His client should have provided him all relevant documents, including this one.
The difference between should have and did are two different things. So I think at this point, I'd like to see if you guys can resolve this before we move forward.
Well-
If it's in your file already, is that a problem for you?
Well, yes, it is, because not everything within the database of Madera County is an exhibit in this case. The pursuant to the civil service rules, the parties are to compile their exhibits and exchange the exhibits and witness lists 10 working days prior to the hearing in an attempt to avoid discovery disputes.
Sure.
And so I would object to deviating from that. Unless this is impeachment or rebuttal evidence, which of course they are permitted to have, but since it's not a county witness, I don't believe that it would be impeachment or rebuttal evidence.
You have a response to that?
It could also be impeachment or rebuttal evidence. I mean, one way or another, I'm going to introduce it, whether it's to impeach one of their witnesses or to introduce it with my witness. So, and I will also say that I'm aware of the 10-day rule. The county has already waived an objection previously as I submitted a new witness with less than 10 days. And so the county has shown flexibility. They're not prejudiced by that, which they weren't previously informed of. Again, this is a document that is not just any County of Madera document in any of its files. This is directly relevant to this issue. It's directly sent in response to the grievance filed regarding standby pay. So it's not just like in the universe, it's directly on point.
Okay, so which document are you referring to that was entered before that was not on the list?
I did not say it was a document. I added a witness to our witness list and
stand
I
corrected.
submitted that amended with less than 10 days and there was no objection.
Do you recall that situation?
Yes, Mr. President, and my email, I'm happy to pull it up, said that with respect to that specific thing, we would be willing to waive it, but we were requesting the exhibit list immediately. But that was prior to the hearing. We are now 3 days into this hearing, and now evidence is being sought to be introduced for non-impeachment, non-rebuttal purposes. So I would object because the situation is markedly different at this point.
I just had a good suggestion from fellow council member here, commission member, excuse me. We're not going to make a ruling on the motion just yet. We're going to meet with our council while you make the copies. That doesn't mean that we're going to enter them into an exhibit, but we want to talk before we make your copies now while we're taking a short break.
Thank you. And may I just clarify, you all are going to confer regarding if I can introduce it now with respect to the
Yes.
union's witness? Okay.
Right.
I just got a quick question for you. What is the, why wasn't this document relevant prior to today?
It was relevant.
Why did you find it not relevant enough to include it in your exhibits?
We all have discretion on what to include and not to include, and as the hearing progresses and you hear what the other side has to say, the questions that the commissioners are asking, things become more pertinent in a way that you could not foresee 10 days before the hearing, months before the hearing when you're preparing for it. And so we would just like a little bit of flexibility to be able to provide evidence as it becomes relevant throughout the course of the hearing. We're definitely not trying to derail this or prolong it more than it already has. And if you look at it, it is directly relevant to the issue that we're discussing, and we think that it would shed some light.
Okay, like I said, we're gonna go confer and then we'll. Okay, make your copies and then we'll come back after we confer with our council.
If I may briefly, in terms of the rule, I have my rules in front of me, but would you mind stating that where the 10 rule is found specifically, and then of course, so I'll point that to them as well. 2.5, yeah, 2.5.110 or
So it's County Code Section 2.57. I believe it's 130. I don't have that, but it's Rule 10-4 for hearings, subdivision A3. Both
Thank you.
parties or their representatives shall share evidence and a list of witnesses that are to be called at least 10 working days prior to the hearing.
thank you.
Okay, 5 minutes. Okay, after a long discussion. Union representatives, council, our question is, you had since last night, 9 o'clock till 5:30 to present this to the other council. Why didn't you do it sometime earlier?
Right. I understand the deadline to be what council already explained, which is the 10 days before the hearing. I think after that fact, I'm not aware of additional deadlines that I should do it by a certain time in the day or at a certain time in the hearing. And so,
That's not my question. You had an opportunity to present it to the council and see if you could come up with a resolution before you got here, instead of blindsiding council now.
Mhm.
You know, that's just not right, the way to do that. I don't want to be treated like that, and I don't think he does either, that we need to present this conflict before it comes into this chamber. And
Understood,
that's our point.
understood.
So with that being said, we do try to hear all kinds of different evidence to try to expand our knowledge of what the situations are and how they get there. So at this point, I'm going to overrule your objection because we want not to allow this to become evidence, but to kind of see where it leads. And you have to prove that it is valuable evidence to be presented
Yes,
and be turned in as evidence.
thank you.
Do you mind
Does-
if I clarify?
Yes, please.
Yes, what the chair is stating essentially is that he has decided to allow you to attempt to move it into evidence, meaning so they're going to use their discretion to bypass the rule of 10 days to allow you then to attempt to bring it in subject to further objections and discussions based off of whatever the objection may be.
Understood. Thank you.
And based on the comments that we made, this is a one-time exception.
I understand and I appreciate the exception. Upon further reflection, I would like the opportunity to bring it up as rebuttal evidence, and I'm assuming that for your ruling, I am also allowed to do that in addition to bringing it for our witness.
On the fact that you're going to try to prove this is something that we can move into evidence and that it's relevant.
Correct.
Okay. So right now, you don't want to give us those documents, correct? Until you get to that point.
Yeah, that's correct. So my preference is to wait until the county's witnesses testify and use it in response to that testimony.
Because I don't want this to become something that we're looking at until it's actually time.
Right.
Because the longer something's in your head, the more permanent it becomes.
And council, as we read that, the rule, it does cite on their actions that should be taken for an exception, including the urgency in order to prevent delays to the commission hearing. So that is well defined in there. So I know you stated that aside from the 10-day prior notice that you were unaware of anything else, but that is stated in there. So thank you.
Okay.
Thank
I appreciate that explanation of the rules and it won't happen again.
Okay, thank you. Let's move forward then.
The union would call its next witness Courtney Hawkins.
Okay, is your little green light on? Yep. Okay, I'll read this to you. Do you solemnly swear or affirm under penalty of perjury that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. State your name and position, please.
Courtney Hawkins. I am Senior Contract Enforcement Specialist with SEIU Local 521.
May I proceed?
Oh, yeah, it's your turn.
Okay. It does not need to be sworn in.
No,
I
she
just did.
You did.
Yeah.
Okay. Thank you so much.
You're having one of my moments.
Courtney, how long have you been a contract enforcement specialist for SEIU 521?
I've been a contract enforcement specialist for about 3 or 4 years now, but I've been with SEIU Local 521 since 2013. So what, 12 years?
Okay, and can you generally describe what your duties and responsibilities are as a contract enforcement specialist for the union?
So the contract enforcement specialist role is we basically handle the grievance process as it gets through the higher levels. Once it gets through like the preliminary steps, whether it's a first level grievance or early steps of a discipline, once it gets to those steps, it then transitions to the Member Resource Center and the Contract Enforcement Department.
Do you work with represented employees in the county of Madera in this role?
Yes, I do. Well, when a grievance or something comes my way.
Are you familiar with this standby pay grievance that we've been discussing in this hearing?
Yes, I am.
And how are you familiar with it?
It was assigned to me after it went through the process that I just described. Once it went through that process, it was then assigned to me.
Okay, so are you familiar with the grievance procedure under the SAU 521 and County of Madera Service Unit contract?
Yes.
From your understanding, if a bargaining unit member who is an employee of the county has a concern that they would like to bring to the union, how would they go about doing that?
So there's a couple of ways. They could either contact the Member Resource Center directly if they have the number to the Member Resource Center. That's something that SEIU Local 521 flies publicly. So you could probably throw a stick in there and probably find a place to find that number. Or if they, talk regularly to the field representative, then they can bring it up with the field representative.
What is the Member Resource Center? Can you briefly
Yeah.
explain that?
So the Member Resource Center is basically our sister department. Mostly everything that's where like the grievances or whatnot are intaked, but they do more than just grievances. They answer pretty much general questions for members. I mean, even about union benefits. So they do that. They help our stewards if the stewards are taking on, grievances or trying to chase down contract issues themselves, then they will work with the Member Resource Center through that process as well.
So if the Member Resource Center is contacted by an employee of the county with a concern, is it the Member Resource Center that files a grievance on their behalf?
Not necessarily. So what happens is that once a member contacts the Member Resource Center, the Member Resource Center will work with the member or the steward in trying to kind of flush out what's going on, whether it's a contract violation, if there's even anything wrong at all. They'll try to help figure out if there's something that's grievable under the MOU or other policy of the county, or if it's something that might need to be referred to an agency like Cal Civil Rights Department, formerly DFEH. And so those conversations occur.
Okay, so is it your understanding that the Member Resource Center initiates an investigation of the issue?
Yes.
Does the Member Resource Center work with anyone else within the union organization through that investigation?
Yes, they can work with the Field IO. We have the Member Resource Center has a practice. They don't start working in someone's turf without letting the people who may be impacted by that turf that, something's going on there, maybe like there's a work site issue or something. So oftentimes they might work with either the steward or even the internal organizer, the field representative.
So, is this investigation process important in your perspective,
Oh, yes, absolutely.
and why?
Well, we need to vet whether or not there's a grievance to be filed. We also have to make sure that we know what applicable policy that if there is an issue, what it applies to. Not everything that is a policy or rule of the county is outlined in our MOU. You have your personnel rules, you have your sexual harassment policies, you have all these other policies that need to be vetted. Or if it's something that might, as I mentioned earlier, is more suited for law, like a discrimination or harassment complaint that would go to Cal Civil Rights Department or EEOC. Well, and not to mention, it's just good practice. I'm sure that the county would not appreciate us just filing, frivolous grievance after frivolous grievance, taking up the civil services and human resources time.
What is Unionware?
Unionware is the database system that we use to track the progress of, well, it's more than just to track grievances. It just pretty much houses everything union, all who our members are, what work sites they're in, but it's also used to track the progress of any issues. If we are tracking, say, a pattern of things, it can be used for that, like say, there's a specific grievance that keeps happening in this particular department. And then it also tracks the cases itself.
Who within the union inputs data into this Unionware database?
So there are only specific individuals that are given certain permissions to that system. Say, for instance, the field representative may be given permission to look at their members in their turf, and maybe track like any phone calls they may have or any positions they may have in the union. Someone like me, I have access that's a little bit deeper, which may talk about any cases that they have brought before the union, or um, yeah, any cases that have been brought before the union. Member Resource Center has similar access to mine.
Okay, is the data input into Unionware in real time generally?
Yeah, for the most part. I mean, when someone gets, like, say, for instance, if I'm working with a member and they tell me something that's significant that needs to be noted in the system, I typically, working off either my notes or if the system is open in front of me, I input the information that was given to me. Or if there's documents that are supplied to me from, say, for instance, a member receives a final disciplinary action, I might reach out to them and say, hey, I need that disciplinary action as soon as you get it to me. It may take them a few days or a week to get it through, especially if they're not good with technology, and then that will go into the system.
Okay. Have you recently reviewed the Unionware data with respect to this standby pay grievance that we're in this hearing for?
Yes, it is part of my process for preparing for this matter.
Is there any information in Unionware regarding when the union first learned of the standby pay
Yes.
issue? Okay, and what data is in Unionware about that?
So the earliest note that's in there was made from one of our employees in the Member Resource Center, and it looks to be on or about May 17th,
What year was that?
2023.
Is there additional relevant notes about what occurred on May 17th, 2023?
It just says very generally that there was a call or something that come in from members regarding concerns about standby pay.
So when MRC received this call on May 17th, 2023, what would have been their next step to respond to this concern?
Well, like I explained earlier, they would probably, I would imagine that the process would, and I can't speak for that person, but the process would be as we are trained to begin working with the steward, the members, and the field IO on what that issue may or may not be as they go through the investigatory process.
Mr. Hawkins, could you slide your mic a little closer to the?
Okay.
Yeah, we're getting a couple skips there once in a
Okay,
while.
all right. I
Thank you.
moved it because
You have a good voice, but once in a while.
Okay.
And so do you know who the internal investigator assigned to this standby pay grievance was?
What do you mean internal investigator?
Sorry, who was the field representative that you?
Oh, Miguel Berrigan.
And I believe his title is, what is his title?
His title is internal organizer, but people commonly refer to us as field representatives or business reps. Maybe bring it back this way. Oh, okay. There we go. How's that?
So when did your involvement begin with this grievance as a contract enforcement specialist?
So the case was assigned to me sometime early June. I want to say early to mid-June. I don't recall the exact date.
Do you recall in what step of the grievance process the grievance was in when you joined?
So according to what I recall from the system, the written grievance had already been filed, because that happened on 6/1 of 23. I was actually assigned the case after that. So according to what I recall from the system, I want to say that I recall there had been an attempt at communication by the members to start the conversation with management.
And was this information was in Unionware?
Yes.
And was the information in Unionware in the form of a note or was it an email attachment? Do you recall?
So there's typically both. There could be just a note about whether or not something occurred, like an event occurred, or if there is an important email, someone could, PDF that email and then include it into the documents if they feel that it's relevant. Anyone who has access to the case.
Okay. Can you open your binder and look at Union Exhibit 4? Page 1. And let me know when you're there.
Okay.
Okay. This is an email from you to Susan Carter dated June 28th, 2023. Have you ever seen this document before?
Yes, I have.
Okay. And who is Susan Carter?
Susan Carter, I believe, was either the human resources director or acting human resources director or something like that at the time. She was the one who I had majority of my communication with throughout this process and others.
So if you see in your first sentence in this email, you're referencing a meeting that was held today. Can you elaborate on what that meeting was that you're referencing?
I believe that there was a meeting being held in an effort to try to resolve the grievance. From what I had understood, from what had been shared with me, that members of management and members of the union were meeting to try to come up with a resolution to the grievance.
And from your understanding, was this a grievance meeting?
From my understanding, it was a grievance meeting.
Okay. Do you know who was in attendance on behalf of the county in that meeting?
It's my understanding that it was Susan Carter. I'm sorry, I can't remember his first name, but McComb. I'm not sure who else they had across the table from them. And then on our side of the table, I believe it was Miguel. I think they had said the steward, Aaron Herring. I'm not sure if all the grievance attended, but I believe the grievance, at least one or two of them attended the meeting.
Okay. And based on your understanding of the grievance procedure in the relevant MOU, at what step in the grievance process does the union meet with the human resources representative?
They typically meet with the human resources representative at step 3.
And who would that person have been in this case?
The human resources director or their designee. And so, I mean, it's very specific. I think it would have been Susan Carter who they had met with, would have been that person.
Okay, are you aware, at step 2 of the grievance process, is the union or the grievance intended to meet with at that level?
The department head.
Okay, and to your understanding, who is the department head?
I
Who they
believe,
were?
I believe it was McComb at that time.
So at the time that you sent this email, and after this meeting had occurred, what was your understanding of where the grievance was in the grievance process, per what you just said?
Say that one more time. I'm sorry.
After you sent this email and this meeting occurred that day, what was your understanding of where the grievance was in the grievance process
On
at
the
that
grievance
point?
process, I take it as it was the step 3, as Susan Carter was part of that meeting.
You mentioned in this second paragraph a 10-day extension. Can you elaborate on what you're referencing there?
I believe there was a conversation between Miguel Barragan and Susan Carter. I believe it may have been an email or something in which they agreed that while they tried to um, resolve this issue, that they would extend the deadlines of the timelines of the grievance process 10 days. And so this is my understanding that this second paragraph, I believe is what you're referring to, is in reference to that.
Okay. And the 10-day extension was between what steps of the grievance process?
Well, it would have been step 3 going to step 4, because the next step after this was essentially mediation because there was no one else to go to.
Do you know what it means for a grievance to default at a certain step?
Yes.
Okay, can you explain what that means?
So if for whatever reason, the parties don't, fulfill a certain step. For instance, if, someone says, hey, we're at step 1, but, for whatever reason, we don't want to meet with this particular person at step 1, so we're going to step 2, well, then we default that step 1 step. And so we just move to the next step. If there's, hey, an attempt to meet and we don't get a response, we default and we keep moving down the process until we get a response from someone. So each time that those sorts of things occur, you can call it whatever you want, but I heard it's been called a default or a skipping of the step or whatnot.
So if someone refuses, someone, let's say on either side refuses to meet at a certain step, or if someone on the county's side refuses to meet at a certain step, does that mean that the grievance stops at that step of the grievance process?
No, in fact, they can't. They can't refuse the process under, if anyone's familiar with it, Government Code Section 3500, also known as Myers-Melise-Brown, which applies to the county, that the county can't refuse to say that we're not going to follow the steps of the grievance or refuse to arbitrate if there's arbitrate or civil service provisions within the MOU.
Does there need to be a mutual agreement for a grievance to default at a certain step and then proceed to the next one?
Not necessarily. I mean, an example would be if I submit a letter to the county saying, hey, I want to meet at step 1, and they simply ghost me. If the timeline lapses, then I just go to the next step. I say, hey, I didn't hear anything from you guys at step 1. So, we're moving to step 2. Not that either party mutually agreed to anything, just there was no conversation to be had. So there's nothing else to do but to move the process forward.
Based on your understanding of this grievance process that occurred with regard to standby pay, did the grievance default at any step of the grievance process?
Well, from what I know and what I've seen in the documentation and what's in Unionware, it appears that there was an attempt by the grievance and Miguel to try to meet at the first 2 steps, with the supervisor and then subsequently the department head. I think where they landed was that when they finally met with the department head brought along who would have been the third person, who was human resources.
Okay.
I think that it's also important to note, though, that the first response, I guess, that we received from management was from Susan Carter, which was a denial of the grievance. And that is just jumping the entire process if that, in fact, came from her.
So can you open your exhibit binder and look at County Exhibit 2?
Oh.
And let me know when you're there.
Okay. It's a document dated June 15th, 2023.
That's right.
Okay.
Have you ever seen this document before?
Yes,
Okay, is this the grievance response that you were just referencing in your testimony?
yes.
Okay, and who is it from?
It says from Susan Carter, the Human Resources Manager.
And so what is your understanding of this grievance response being from Susan Carter, the Human Resources Manager?
Well, being that this, so like I had mentioned earlier, I think we kind of discussed that there's 3 steps. The first step is the supervisor. The second step is the department head. The third step would be human resources. If this is coming from human resources at the first step, that this decision supersedes step 2 and 3, because there would be no one else to go to. We would get back to 3 and it'd be back here where we've already received a denial.
So after you receive this denial of the grievance from Susan Carter, from your perspective, would it make sense to then go back to step 1 to get a response from the immediate supervisor?
Not necessarily. I mean, unless you're still hoping and praying that, someone's going to address the issue at hand. But other than that, no.
Okay. At this point, I would like to move Union Exhibit 4 into evidence.
No objection.
Exhibit 4 of Union Exhibits.
Commissioners, may I grab my water? It's right here.
Yes. Thank you. I believe I'm done with my direct examination, but before I conclude, I would also like to move Union Exhibit 8, which I don't believe has been entered into evidence. No more discussion.
No objection.
Thank you. And I believe the only exhibit that's left is Union Exhibit 5, which at this point the union would withdraw. And so I believe that all of the union exhibits have been entered into evidence.
To the withdrawal of Exhibit 5? No.
And with that, I've concluded with my direct examination. Thank you.
I don't have any cross-examination.
Yeah, I just wanted to kind of piece together Mr. Berrigan's statements from yesterday. Because yesterday he had stated that there was a handoff between, which would be him, and then a contract enforcement officer. I just want to confirm, would that be you?
At some point, yes.
Okay. The member resource center are the individuals who take calls or emails or complaints, are they made aware of contracted timeframes in MOUs?
I would imagine so.
Okay. To the best of your knowledge, do they advise employees to acknowledge with the, or to not acknowledge with employers to prevent like contractual clocks from starting?
I don't understand your question.
Um, we had discussed, how in the contract, there's the 10 days from the employee having, made aware of an issue, right?
Okay.
And so that by definition would start the contract, or the 10 days according to the contract, right? The 10 days to file official grievance. And I was just curious if the Work Resource Center, if they're receiving these, these complaints, if it's their process to give any type of advice to the union member who has an issue, to, to allow the investigation on the union's end to occur prior to bringing up the issue to their employer.
I can't really speak to what a member resource center employee would necessarily advise or not advise. I'd have to have more context of the particular situation.
Sure.
So
Um, is there a process in place if a, union member brings up an issue and states that they have already, raised the concern to their direct manager or supervisor, in this case, a representative of the county? Is there, any type of expediting that occurs on, through the member resource center?
I can't answer that. I
Okay.
mean, like I said, I don't think there's any internal process I've seen that says, we have to expedite something. I mean, people are aware of the timelines.
Right.
But as far as you're saying, like, rush it through,
Sure.
I can't really speak to whether that
Right.
ever occurs.
To prevent, I guess, to prevent the 10 days from, elapsing on you, or in
Mhm.
order to kind of understand, oh yeah, here we have a situation, it's already been made aware, our clock has started, so now we have 10 days to either file this grievance or not.
Right.
And so maybe like a prioritize button or something.
Right.
And I ask these questions because this hearing was asked or requested, on your team's behalf to be made public.
Mhm.
And so I can't help but to always think that there's thousands of people listening to this, thousands of, employees, other employees, who some may be represented by the union, so that they understand this process, right? Because, we sign things and sometimes we don't always, read through them, and we rely on, agencies or groups like the one that you're part of, to help us with those formalities and processes. So that's where my curiosity came from.
I think you're asking questions that can be situational and circumstantial.
Okay.
I mean, different MOUs have different, different terms and conditions, and the relationships can be different where people are trying to work things out. Some places could be like, that's it. We don't want to work it out. It's war every day. I hope that's not the relationship between us and Madera County. That hasn't been my experience. We don't always get along, but I think we're at least business cordial.
Mhm.
And so to have the idea and say that, well, as soon as SEIU gets a call, we should run forward with a grievance, as I mentioned earlier, I think that's just, that damages labor peace. Like,
Right.
if I come to it, I'm sure the civil service will not be appreciative of a line of employees out the door because Courtney Hawkins is filing a grievance for every single person who comes to me with a problem. The same way you had mentioned, I think yesterday, that we've spent 4 nights here speaking of this issue, regarding this grievance. I don't think that you would appreciate spending 4 nights a week for every issue that comes through that door. So our attempts at, trying to vet a grievance, trying to get the information, it's all in an attempt to try to make sure that with what we're bringing forward, it's appropriate, so that when it lands before you, we can actually have, the discussions that we're having now.
Right. I was, curious about the handoff, the process, right? So our employees, our Madera County employee who's a union member, has the complaint. And in this case, it was, we don't have the exact date, that Mr. Berrigan was contacted, but, it's late April, early May, at some point he was contacted, and he had said, that his, his obligation is to escalate it to the contract team, the contract person to review that, right? In your testimony, you stated that you received this May 17th, correct?
No, that's not my testimony.
Okay,
It was, the first call came in to the Member Resource Center at May 17th. That's not when I received it. I didn't receive it until after, I think, early to mid-June, maybe. And by that point, there was already a formal grievance
okay.
in the process.
I appreciate you clarifying that. So Mr. Berrigan's, the process that he had highlighted that he follows, there seems to be a gap, right? And so that's why I had asked that question between, early May, May 17th. Then so I'm just trying to piece that timeline together because I understand it was 2 years ago and everybody's, dates are kind of vague right now. So I just wanted to understand that process and how that was handed off to you. So,
And to be fair to Mr. Berrigan, I mean, like you said, it's been 2 years since we've been trying to, well, schedule this with you good people. I mean, this process happened a while ago, and even as of late of the last date that we were supposed to be here, it's been canceled on us. So you had mentioned that yesterday about the importance of bringing these issues before the civil service and getting people's issues addressed. But we've been trying to get this addressed for over a year and a half, and it's been primarily either county council or civil service commission that has kind of held up us getting here to this position. Now, I'm not pointing fingers at you guys. I know that you guys have, things happen, but we have been trying to get this, and I have tons of emails of my attempts of trying to get this before you so that we can get some sort of resolution one way or the other.
okay. Well, we're here now, so that's why we're doing our due diligence and going through this as thorough as
And
possible.
I appreciate that.
And last question, you had mentioned when talking about the process and what would constitute as a default, you used the word, unless we were, ghosted, or at least,
Mhm.
Could you define that? How do you define ghost me?
So in my work, there's been times where I've sent, requests for step 1 or step 2, and I've received no response from the employer.
Okay.
So that's my definition of ghost.
So no response at all.
Yeah,
Okay. Not
absolutely no response.
like the scary ghost where you get a little bit of
Yeah,
a little
Just
bit here and
absolutely,
there.
Yeah,
Okay.
the what do they call it? Generation Z
Yeah. Okay.
definition of ghosted, that, they
Just
just didn't
completely
get a response from
completely no
anybody.
response.
Right.
Okay. Thank you for defining that.
Mhm.
That's all the questions I have.
Brett Wood?
Hi, Courtney. I just want to double check dates because you mentioned May 17th, and to Mr. Berrigan, he was April or May. I just want to know dates that the
So-
union was.
So what I can tell you, according to the system, that I guess preliminary contact was on or around May 17th. And so in there, I would imagine that somewhere between May 17th and I believe when the next there's, if I recall, I can see it in my head, but I think there was like a couple of little notes there about working through the process. I think, an intake form was filed, but then the actual grievance was filed June 1st.
Okay, but I was hearing references to April and early May.
No, I never say anything about.
No, you didn't, but
Oh, okay.
Mr. Berrigan, I'm trying to figure out when Mr. Berrigan or your union first heard about this. You're saying May 17th. I was hearing about meetings May the,
In
in
April.
March and April.
Well, the meeting in March, that I think that had been clarified that the union was not party to the meeting in March. As far as mentions to April, like Mr. Berrigan had explained, that he was kind of fuzzy as to on and about when that happened. But from what I know, that's actually in the system. First contact on this happened about mid-May, like I said, on or about May 17th. And so somewhere around that point is when I would imagine happen if everyone's doing what they're supposed to be doing, that the person who received that contact would say, hey, this is going on in your area. You need to start having those conversations with whomever. This is what we've been told.
Okay, so that I'm understanding, you're saying it started May 17th.
On or around
And-
May 17th.
Okay, and so the other meetings did not involve SEIU.
The meeting in March did not involve SEIU.
Okay, thank you.
Elizabeth? Nothing? Easy. Mr. Hawkins. In terms of when a grievance should be filed, if you've gone the first, second step and you were ghosted both of those times, do you file a grievance on the first one that you're ghosted, the second one you're ghosted, or until you talk to somebody to see if it's valid to file a grievance?
Well, relevant to this issue, that grievance was already filed. That grievance was filed by the time those conversations were attempted to be held by Miguel Berrigan. The grievance had already been sent by Mr. Aaron Herring on June 1st. So subsequently, those attempts by Miguel to reach out and have a conversation with someone happened after June 1st. So to answer your question, it's not I file a new grievance. The grievance is filed. Hey, you're on notice. We have this issue. We'd like to talk. If I'm ghosted, I will then say, okay, the employer's timeline, I haven't heard anything back. I'm going to move to the next step, right? And so on and so forth. So there's no like, to answer specifically what you asked me, there's not like a new filing of the grievance. It's all one process.
Even if the 10 days are gone, that grievance, that process or the form still continues. Does it start then another 10 days because a party did not respond or ghosted?
Well, if you take a look at the grievance procedure, each step has defined times for each party to respond.
Right.
Right. I think what you're asking me is because I got ghosted and I didn't hear from anyone, what now do I have does the employer now have 10 days? Is that what you're asking me? Like,
Well,
I just move forward with what the language of the MOU says as far as like, okay, I sent a request. I haven't heard anything back to even set a meeting or anything. 10 days has gone by. Move to the next step.
but does that start that clock for 10 more days because you've gone to the second step or third step or fourth step?
Well,
When does it reset? So that,
I would say yes, because now we're in a whole new section of the MOU that says, hey, 10 days, from this. So after that first 10 days, let me put this. So we request a step 1 meeting. We don't hear anything. 10 days goes by. Okay, I haven't heard anything. I guess I'm not gonna hear anything back. I go to step 2. I wait another 10 days or whatever the timeline may be. Different contracts have different timelines. And I wait, don't hear anything back. I'm going to the next step. All the way up to, depending on whatever it is in the contract, up until I am putting in the request for mediation, civil service, or arbitration. I just walk it through its paces if I'm not hearing anything back. If I hear anything back, then meetings are set, people talk. We are either granted or denied. We either accept it or deny it with the answer and move forward to the next step.
and for clarification, 10 days means 10 working days.
Maybe I can't really speak to that because different contracts have different things. So I could say yes, 10 working days, but I wouldn't be able to affirm. I'd have to look at the language, sir, to see.
And the response time from the other side is the same length of time.
Yeah.
With the same rule.
Both sides play with the same rules, yes.
All right, that's all I have. Okay, Joe?
Mr. Hawkins, earlier you said that you answer general questions about the grievance, right?
Say that one more time, sir.
You said that you answer general questions about the grievance.
I can, if people have
Okay.
questions for me, I can answer their questions about the grievance or the grievance process.
Do you get these questions from the grievance, the people that are the grievances? Do you get it directly from them, or how do you get this information?
Oh, you're asking how do I get the information about this about the grievance process or about what's going on with the grievance?
Well, the process you indicated that you get it from the supervisors and the department heads. Is that what you said?
No, let me, hopefully I can do my best to try to answer your question. So when I'm investigating a grievance, I get information from the grievance. I may request information from management, and I may refer to the applicable policies to the issue when I'm doing my investigation. So I'll answer that. Hopefully that's responsive to your question and what you're asking.
Okay, so in actuality, you never meet with the grievance, right?
No, I meet with
As
the grievance.
individuals.
No, I meet with the grievance. Either, in today's world of technology, it may be phone, Zoom, or sometimes in person, but I often meet with the grievance.
So all the information that you get is through correspondence from the department heads?
The information that I get from management, you're saying?
Yes.
Well, the information that I get from management can come by way of things that they say in meetings, if they actually meet with me, or through information requests that the union submits in our attempt at getting the most relevant information to competently represent our members.
Okay, thank you.
Abe's got another question.
Yeah, Mr. Hawkins, in in respect to your position, when do you consider a union member and a person of a grievance, or now going from a union member who is now a grievance?
I'm not sure.
When does a person become a grievance as defined in the procedures? In the procedures, it refers to an individual as a grievance.
I think that's kind of one of the things that are at dispute, that there's been this back and forth from what I've seen about what defines the grievant and, who defines a grievant. And that is something that I don't think is specifically defined in the MOU, because typically, let me give you an example. If you go back and you look at the county policies, I can almost guarantee you're going to find in the beginning of those policies a list of definitions for various terms that are used. You guys are probably all familiar with that. One thing that I haven't seen in this, and maybe this is something because negotiations is coming up soon that may need to be defined,
Yeah.
but who and what a grievant is.
So from your perspective, does an individual need to have filed a grievance in order to be considered a grievant?
Again, that's kind of subjective. I mean, I could say from the time someone comes to me and says, I have an issue with the boss, did you call them a grievant? Or do we say from the time that they actually put something down on paper that they're agreement? So I think what you're kind of asking me is subjective, because that piece is missing that I described.
Could you please refer to Union Exhibit 2?
Okay.
Under section 902, adjustment procedures, if you could just let me know when you're there.
What page is that? Oh, okay.
Page
Got it.
one on mine.
Found it.
Okay. The second paragraph, would you mind reading that to yourself, or just read the first two words to confirm you're there? A written grievance?
The beginning with the written grievance?
Yeah.
Okay.
Based off the language used here, would you consider would you consider the document considering an individual a grievant prior to filing an official grievance form?
Say that one more time?
Based off the language written here in this paragraph, would you consider the interpretation of a grievant being somebody who is, who has not yet filed an official grievance form?
Well, there's no reference of the grievance form in that line as you asked the question.
It says a written grievance must be filed within 10 working days from the
Mhm.
time the grievant becomes aware or should have became aware of the issue or incident giving rise to the problem.
Okay.
So if they have, it's classifying the individual as now a grievant,
Uh-huh.
if they have 10 days to file the grievance, then they would be considered a grievant prior to a grievance form even being filed, correct?
That statement could be interpreted that way, yes.
Okay, well. How do you interpret that?
Well, typically, if there's an issue at the workplace, it's my experience that that issue has probably been going on for some time before it's brought to the union's attention. So I guess I would need the context as to how long a member may have known if the union had been made aware, right? So that we can begin working on it. That's the best way
Okay.
I can interpret that for you.
Thank you, Mr. Hawkins. I know my questions are long-winded, so I appreciate you bearing with me.
I can give long-winded answers.
I didn't quite get an answer on that last one, but
Yeah,
I got a
that's fair.
response, but that was
That's
fine.
fair. That's fair.
All right. Thank you.
Let me try to muddy this water some more. If a situation is going on for, say, 6 months,
Mhm.
and an employee has talked to their supervisor, nothing's happened, they've talked to HR, does that mean a grievance should have been filed at the beginning of that 6 month period?
That's fair to say. Well, if they've had the conversation with their frontline supervisor, trying to handle it informally, and there's no traction, they've gone to HR, there's no traction. Um,
So the system basically tells you, we're gonna file a grievance before we can even talk amongst ourselves about the problem, to see if we can solve it before we come here.
and that's where I'm saying, like, this is why we're having this debate. That's why we've had this conversation several times. We don't even get the opportunity to be able to investigate and really get to the fact of the matter. So I think that this is some cleanup that needs to happen in negotiations, frankly.
That's my point. Because
Exactly.
this is,
I would,
it's
me and
crazy.
you agree with that. And it's not fair to either party, right? It's
not
not
at
fair
all.
to the grievant because they need to, we need to be able to work with the, whoever is,
I make this kind of language here, kind of compare it to a husband and wife. Oh, we're gonna go talk to the divorce lawyers before we try to talk about how to solve the problem. So you make a threat before you solve a problem.
and that's why
Discuss it.
Mr. Berrigan was trying to, I think, arguably, well or not, but he was trying to convey that, talking about the informal process. And to make a note, if you look at the first step of our grievance process, if you were to take that language, and this is where I said there might be some cleanup needed um, in the contract between the parties. If you look at the first step about going to your immediate supervisor and you compare that in other contracts, you'll see that that language is considered informal, an informal step. And so I think that's why Mr. Berrigan was making those references to the informal step of trying to resolve the issue before we get into the ugly litigiousness that we're sitting in now.
Do you have any more questions from the commission? Hearing none, does that bring up any ideas of cross and redirect?
Yes.
Okay,
Thank
go
you.
ahead first.
Um, Courtney, who are the parties to the MOU?
The employees, the union, and the obligations of the employer.
Okay, who's, from your perspective as a union representative, whose job is it to enforce the contract and make
The
sure it's
union.
being? Okay, is it individual employees' obligation to enforce the contract?
No, it's not.
And why, from your perspective, is it not individual employees' obligation to enforce the contract?
Well, they may not necessarily have the correct interpretation or understanding or knowledge of this whole process to do that. And so that could, result in, it's like going to trial court without an attorney. You're gonna get it wrong. So the union is there to enforce the contract for its members.
And from your perspective, do most members know the contract front to back perfectly?
No,
Okay, and whose job is it to know the contract front to back perfectly?
the unions.
Okay. So I think a lot of the commissioners' questions are trying to get to that trigger point of the grievance procedure where it says 10 days from when the grievant became aware.
Mhm.
And Commissioner Perez brought up some examples about, and maybe Commissioner Fry as well, about employees bringing some issue directly to their supervisor and directly to human resources. From the union's perspective, does that trigger knowledge of a violation of the contract?
Not necessarily, because someone could go to their supervisor saying, hey, I have a problem. And the supervisor could say, well, it's not in the MOU, and that's where that debate begins. The member could potentially be bringing something to the supervisor that is something that they're not entitled to grieve, right? And so just an employee going and bringing it out before a supervisor doesn't necessarily mean that it's a grievance.
Okay. And what do you mean that employees bring something to their supervisor that they're not entitled to grieve? What does that mean?
So, between the MOU, between, the county policies and between the law, there's things that the employees are entitled to. There's things that the employer is obligated to do. And then there's those things what, we do in steward training call the gripes and the grievances, right? So you have these things where it's a gripe, but it's not necessarily something that is enforceable under any of those policies.
Okay. And so in order to file a grievance, does someone need to determine whether that gripe or grievance is enforceable under the contract?
Yes.
Okay. And from your perspective, are most county employees, do they have the tools to make that determination by themselves?
No.
So from your perspective, why is the union's knowledge of a workplace issue relevant or important to the grievance process?
Well, because we do this for a living, that we are the ones who help navigate the, waters with the employees to show them what they are entitled to under applicable policy, MOU, or law, and as far as what the obligations of the employer may actually be versus what they may want or desire.
Okay. I would like to clarify the timelines here. So you've testified that from your knowledge, the grievance in this case was filed on June 1st, 2023. Is that right?
If I recall the document, yes.
Okay. And to your knowledge, did Miguel Barragan, did he start trying to initiate the step 1 meeting per the grievance procedure before or after that written grievance was filed?
If I recall, from off the top of my head, I believe it was after the written grievance was filed.
Okay. So can you look at Union Exhibit 3? and turn to page 3, which is an email from Miguel to Ryan dated June 5th, 2023.
Three.
Yes, Union Exhibit 3,
Page 3.
page 3.
Okay.
Have you seen any version of this email in Unionware otherwise?
I think it is included in the documents in Unionware.
Okay. And so what was your understanding of why Miguel was reaching out to Ryan at this point?
Because that's step 1 of the grievance process.
Okay. And at this point, when this email was sent June 5th, 2023, was the written grievance already filed?
Yes.
Okay.
It had been sent by, or had been signed by Mr. Aaron Herring.
Okay. Now can you flip to Union Exhibit 2, page 3?
Bit 2.
This
Page
is
3.
an email from Ashley Diaz to Ryan Knoll, and it has Miguel copied and others.
I think I'm
dated-
on the wrong page. Okay. 2, 3. Yes.
Okay, and this email, do you see the email from Ashley dated May 17th, 2023?
Yes.
Okay. So based on your previous testimony, this email would have been sent the same day that the union was first contacted, is that correct?
Yes. According to the date that was in Unionware that appeared to be the first contact, which was on or around May 17th.
Okay, and just to clarify that May 17th date, because we've heard dates in April,
Mhm.
earlier May, from the data that you have from Unionware, would Miguel or anyone else in the union have been contacted prior to that first contact date, May 17th, 2023 in Unionware?
Wait, so ask, I guess ask me that again.
So,
I'm just-
based on the data that you saw in Unionware,
Uh-huh.
with the first date of contact being May 17th, 2023,
Mhm.
would Miguel or anyone else in the union have been contacted before that date if it's not in Unionware?
No.
Objection assumes facts not in evidence, calls for speculation, and the witness lacks foundation to speak to who anybody in the union might have spoken to it at some point.
What? I believe that I set a lot of foundation as to how this knowledge came about, and this database has extensive information about this grievance.
My issue is he's in a position where he's gathering information from all the people that are in front of him before it comes to him. So where does he not have foundation for all
he- The question is basically if it is not in Unionware, then did it not occur? So does Unionware identify every single contact of every single grievant? And this witness does not have the foundation, does not have the knowledge to speak to that. To every single, there could have been informal communications, there could have been any number of things.
Hang on a minute.
Okay.
I need to decide what I want to do with this. I guess I'm having trouble understanding that because who better to know what's Unionware has information of than this gentleman? Since he's down that line of progression that far. Now, maybe the private conversations, I would agree with you, but as far as what might be in Unionware, he should know what's in there.
No, I agree with you. I think we're talking about two separate things.
Okay,
I'm not talking about what is in Unionware. I'm talking about what could not be in Unionware. And this witness is not capable, based on his knowledge as an individual, to testify that there are no conversations that are not in Unionware.
so you're assuming that he's not had a private conversation with anybody else other than what's in Unionware.
I'm stating that he as an individual does not have the the knowledge of every single conversation of every single member of the union.
Okay, can we make the objection specific to specific conversations, or are you just gonna have a blanket for all of them?
Well,
we
my,
have-
my
'cause-
objection goes to the foundation and that this witness singularly cannot have information about every single conversation and then credibly testify or have the foundation to testify that all of those conversations are in Unionware.
Yeah, I get where you're going at, so I'm gonna go ahead and sustain your motion. Does that make sense,
Yes.
Ashley? Okay.
Courtney, can you just clarify again, kind of as it relates to this standby pay grievance? The scope of information regarding communications that the union has had with grievance, what is included in Unionware?
Most major events. So first contact, um, steps, in which the like if there's any communication that moves the steps of the grievance, responses from management. You know, if there's any major information that is, you know, provided by a grievant or a steward or anyone related to the matter, usually makes its way into Unionware.
Okay, and based on that database, can you remind us when the first contact was between the grievance and anybody in the union?
Around May 17th, on or around May 17th, 2023.
Okay, and then you're looking again at Union Exhibit 2,
Yes,
page 3. That's also dated May 17th, 2023.
yes,
Is it your understanding that that first communication in this email was made on the same day?
yes.
I believe I'm done with my question. Thank you.
Okay. Is there anything else from county?
Yes, a few questions. Thank you. Mr. Hawkins, good evening. I just have a few questions for you. So who inputs the data in Unionware?
Either, well, like I mentioned before, it depends on what part of Unionware someone's working in. So I guess I would need to know what are you referring to as far as, because it's Miguel, he puts in information relating to whether employees are wanting to be activist stewards or whatnot. If it's someone from MRC, they may document phone calls or whatever that may come from members, maybe even case updates. Similarly, I do that, but more at the higher level. Once it gets handed off to me, anything that comes in goes into the system input by me.
Okay, so is it true then that it is not an automatic input? It has to be manually input by somebody?
Yeah, I mean, unless we have the ability to go from mind to computers, yes.
Sure. Well, I mean, there are email tracking systems where, you know, every email that comes in, it automatically goes into an archive or something like that. But that's not the type of system this is?
Yeah.
It has to be manually input?
Yeah, it's manually input.
Okay. And isn't it possible then that people forget to put information in Unionware?
I hope not, because that could be definitely a discipline coming. But for the most part, anything's possible, I guess.
Okay. And you mentioned that most major events are in Unionware. Would an informal conversation with a potential grievant, but somebody who you hadn't done the research maybe related to the grievance, would that go in?
If they contacted us saying, hey, you know, I have this issue, and that first contact, likely it would have been into the system, even if it was determined, hey, there was a discussion, this isn't a grievance, it would be the event, person called, no grievance, case closed.
Right. And that's if they remember to put it in, right?
Yes, yeah.
No further questions.
Now it's got me going. And in response to his question, you made a comment just recently that if somebody didn't put something in this program, there would be a discipline coming. Has
Ye-
this happened that people have not put stuff in?
Not in the years that I've been there, and just to give you a little bit, lay some foundation for my knowledge, I'm the chief steward of my union within SEIU. Well, I was for some time now. And so I have a lot of knowledge of who does get in trouble and who does not get in trouble in SEIU. And no one has ever come to me saying, hey, I'm getting in trouble because I did not put anything into the system.
And there are guidelines, strict guidelines on what is and is not put in there.
Yes, we're told to do, if the phone call comes in, I'm told to get that information in there. If I get a document, I'm told to get that document in there. If I go and I'm looking for a particular document and I can't find it, I'm on the phone with the person who, might most likely would have that document.
And I suppose there's timelines to make things input timely.
Well, yeah, no, we try to make sure that they're in there no less than 24 hours.
All right, that gives me peace of mind. Okay, one more question.
Yeah.
Mr. Kern.
Yeah, Mr. Hawkins, you had expressed the potential need to renegotiate the contract and clean up some language and, perhaps, the process entirely. On your union side, your process, we heard from Mr. Berrigan, and he stated that, when he gets a complaint, made it very clear, there's this escalation piece, right? Let's review it with the team. Let's the contracts team, let's get them involved in order to determine the, whether or not we have substance to the matter. Um, do you feel being head of the department there on your end, that it was good practice to have Mr. Berrigan encourage an email to go out requesting a meeting on the same day that he, according to the software, Unionware, first received information?
I can't speak to that from being the head of department because that I am not.
Okay.
I'm just another wheel in the cog.
Is it common practice to, on day one of receiving this information, to encourage an employee to set up a meeting via
Well,
email?
Well, so as I explained earlier, and as you can see in the email that you're referring to, this is a preliminary or informal step, as I described earlier, with her frontline supervisor. And so, just like I had mentioned earlier, we try to have those conversations in order to gather information and to try to resolve the issue as early as we can. So, do I think that there's anything wrong with having the employee try to get that set up? No, I don't think there's anything wrong. I think that once she's had the conversation with her union rep and that, they've talked about the process, what you may or may not be entitled to, how the process goes, I don't think I would probably give that same advice. Hey, so let's set up a meeting with your boss so that we can see if we can resolve this.
And you gave me an example of having a line at the Civil Service Commission for every complaint that was, brought to us, without being vetted properly. Do you think that this process may result in the same result, having a line of meetings wanting to, a huge line of requests? Hey, day one, I have this issue. I'm gonna enter into the system. By the way, set up a meeting. Let's talk about it.
I think that would be subject to how reasonable the parties are in their conversation. If management is stonewalling us, and if we're stonewalling management, the process will move will move forward.
Right.
So I think it would just be dependent on whether or not the parties are amenable to truly trying to resolve the issue.
Sure. Okay. Thank you.
Bill, you had a question?
Yeah, for some time. Hi, again. Looking at the May 17th encounter, Mr. Berrigan and, excuse me, Ashley Diaz. I'm going to assume that Ashley at some time during the day of May 17th, excuse me, made a phone call or sent an email to Mr. Berrigan starting this process. I don't have a copy of that, so I don't know if there's a phone call or not. That's neither here nor there. I'm going to assume that he probably didn't take the call right away. He might have been busy. I don't know when she called. He gets back to her. She explains the problem. He has to check his calendar. So they're going back and forth. Well, I'm available this and this and this. And it makes sense that he would have said to her, let's see if we can talk this over with your supervisor. That's what I'm understanding is the procedure that you think he would follow.
Yeah.
And 4 minutes before end of shift,
Mhm.
Ashley sends a note to Ryan. Hey, my union rep wants us to meet. And here are the dates. So some time has elapsed during the day
Mhm.
between her initial contact, getting back to her, him checking dates. Okay, am I understanding this correctly? So that would have been the procedure. He would have said, hey, let's try to work this out.
Right. Yeah, and I think he tried to speak to that as much.
And then
as
she
he-
waits till the end of the day. She's taking care of her business
Mhm.
for the county. And then just before she leaves, she sends Ryan the note
Mhm.
that she's shutting down. So we could have a 2 or 3 hour lapse here. That seems plausible to me.
Yeah.
Okay. So I have the idea of their contact. Now, would that be in union wear?
I pretty perceptive because
Hey, I want that on the record. Okay.
the call came in at May 17th at 9:23 a.m. So what you said is quite plausibly what could have happened.
Okay, so if you're saying 9:23, I don't know if they spoke right then or that was the call and he called back. I really don't, doesn't matter.
Mhm.
So from 9:23 in the morning until 4:56, we've had that.
For
Span of
this
time.
to get worked out.
Okay. Now I sort of understand the system. Thank you, sir.
Okay, does that bring up any other ideas and questions to ask?
Nothing from me, thank you.
Nothing for me. Thank
Uh,
you.
9:20.
9:23 or 20
Hey.
something around that time in the morning. It was in the morning when the call came in.
All right, and you're done with this witness.
We're done with this witness, yes.
Thank you, Mr. Hawkins. You can change chairs now.
You-
Are you ready for your next witness or your final witness?
So that would be the union's final witness.
Okay,
And we would rest at this point. Before we do, I would like to make a note on the record and have some response from the commission. So previously, our grievance attempted to testify regarding bullying, retaliation in the workplace, and it was my understanding that that was objected to on the grounds of relevance, and that objection was sustained. So for the remainder of the hearing, that was not brought up again. As you've heard, though, the county has some defenses on, asserting that this grievance is untimely and references this 5 years. The grievance have known about this issue for 5 years. From the union's perspective, it is being prejudiced in being able to defend and respond to that claim when the commission is precluding the grievance from testifying about those matters. And so we'd like some resolution or some clarification on how we will be permitted to respond to that, given that from our perspective, those factors are directly relevant to this 5-year timeline that the county is asserting. And so we would request one of two things. One would be that the county be precluded from referencing that the grievance have known for 5 years. If they won't be precluded from bringing that up, we would like the opportunity to bring the full scope of the issues, and that would include any evidence of retaliation, bullying, harassment in the workplace.
okay. Do you have a response to that?
Yes, so, the county one has not, introduced any argument related to the 5 years, so this is somewhat premature, I believe. But, to the extent that that might have been discussed, and, well, actually, I'll withdraw what I previously said, because I think in cross-exam, I did have one of the, union witnesses acknowledge that the county had made that argument. And so, with respect to the 5 years, that's a perfectly legitimate statute of limitations argument. It's called constructive notice, and I don't know if you want me to go into detail about what that 5-year argument is, but it is a statute of limitations argument. And so the idea is that once somebody is on notice or constructive notice, meaning that they have knowledge of something, then whatever that timeline is, it starts. And so our position is that if the grievance are alleging that they have not been paid for 5 years, then they know that they were not paid 5 years ago. It's kind of the idea. And so they've known about this issue for 5 years. That's really it. It has nothing to do with any alleged harassment, retaliation, or anything. It has to do with the knowledge and the timeline under the MOU, which is much shorter than 5 years. Obviously, it's 10 working days. That would be it. And so even if that information were brought in, there's no relevance to any alleged retaliation, even if you were to make the argument, which is somewhat being implied, that the grievance were afraid to raise the issue because of retaliation. That even if they're afraid, there's nothing in the MOU that says that you're excused from this deadline because of X, Y, and Z. It is a hard deadline. You'll hear testimony on that. And so in that regard, the county's position would be the knowledge position, or the knowledge piece, is not affected by any alleged workplace issues that were going on.
And may I just respond?
Sure.
I think the commissioners, I mean, in hearing that the grievance had not been paid already for several years, even alluded to, like, they were curious about why it was that the grievance had not brought this up to HR before, had not involved the union. I think those are legitimate questions and they have a valid explanation. Again, it's rooted in this workplace culture that they were subjected to. I think all of that background is relevant to why it took the time that it did to get where we are. And so again, just to the extent that the county is going to make that argument, which it seems like they are, we would like the full opportunity to respond to that.
Well, I think at this point, when we get into the county's examinations and evidence, you'll have time to argue against some of their points if something comes up. I think we just need to let the process continue on. The commissioners, I know, are listening to everything that's been said. There are certain limits on what we can and cannot do, but we are listening. And I'll just leave it at that.
Okay.
Can
So
we take 5 minutes now before we start with the county side? In case anybody needs a restroom break?
yes, thank you.
Yes, please.
their departments. And then negotiating those policies and procedures with the bargaining units that are that have impacted employees.
Okay, thank you. And you mentioned negotiating, I believe it was successor memorandums of understanding. Does that include with the service unit that's representing the grievance in this appeal?
That's correct.
Okay. And were you involved in the negotiations related to the memorandum of understanding that is in dispute in this appeal?
That's correct.
Thank you. And what was your role in those negotiations?
I was chief negotiator.
Okay. And generally, what did that role involve?
Typically, it involved negotiating specific languages that the county wanted to include in a contract or wanted a provision to be amended. It also meant that we accepted proposals from the union, which then, based on whatever parameters we had from the Board of Supervisors, we would negotiate what we could with respect to whatever's being proposed to us.
Okay, thank you. In that position or in that role, were you involved in discussions with the service unit representatives related to interpretation of contract language?
Yes,
Okay, thank you. Would you say then that you're familiar with the terms of the memorandum of understanding subject to this appeal?
yes.
Who was the representative for the service unit that you worked with in negotiating the memorandum of understanding?
The SEIU representative was Miguel Barragon. And then they have a few representatives on their team that are county employees. The president at the time, I believe, was Donald Allen. And then they have a vice president at the time was Aaron Herring.
Okay, thank you. And have you been involved in negotiations of prior memorandums of understanding with the service unit?
Yes.
Approximately how many?
As a chief negotiator, that was the first contract that there were 13 bargaining units, so 13 total contracts, but this was the first one for the service unit. Prior to my becoming chief negotiator, I was support staff to the chief negotiator. And so I was at the table during numerous negotiations.
Okay, thank you. I'm not going to ask you some questions about the MOU between the county and service unit related to this hearing. So I'm going to have you turn to, let's just go with Union Exhibit 8. And go
Okay.
ahead and,
It is the service employees contract.
yes, it is.
Okay.
And are you familiar with this document?
Yes.
Okay. Now go to page 13, if you will. Let me know when you're there.
I'm there.
Okay. Under section 9, it states grievance procedures. Do you see that?
Yes, I do.
Are you familiar with the terms related to the grievance procedures?
Yes.
Okay, thank you. In your experience, what is required to start the grievance procedure process?
Well, the very first thing to start an actual process is a written grievance. And that can be in the form of an email. It could be in a form of a memorandum, any type of official document stating that they were filing a grievance for the service unit and any units represented by SEIU, they have a formal document that they typically submit when there is a grievance filed.
Okay. And if I could have you just real quick refer to Union Exhibit 1,
Keep my hand on the other exhibit.
please.
Will we go? Okay. Yes, I'm on Exhibit 1.
Do you recognize this form?
Yes.
And what is this form?
It is SEIU's form that they typically submit their employee grievances on,
Okay, thank you.
either them or on behalf of a grievant.
Okay, thank you. And in your experience, this is the form that they use when they are submitting a formal written grievance?
They typically use this form, yes.
Thank you. Okay, now, sorry to have you do this, but if you could flip back to Exhibit 8, page 14.
Okay,
There, the second paragraph from the top, this is under section 9.02. Go ahead and read that to yourself.
okay. I'm done.
So what is the timeline for submission of a written grievance?
10 working days from the time that the grievant either became aware or should have become aware of the issue or incident.
Okay. And as the county's chief negotiator, what is your understanding of the language that the grievant becomes aware or should have become aware of the issue?
So typically, when they're questioning an issue, typically is when it comes to our attention, situations where I believe I should have been paid this, or why wasn't I paid this? Those are issues that then, if they file that grievance, we would need to know the time frame between those.
Okay. And whose knowledge is this referring to?
Objection. This witness lacks foundation to answer that question because the document speaks for itself. I know I made a similar objection before and it was overruled. My point that I'm trying to make is that individual parties, so what this county witness thinks that this means is irrelevant. What the union representative thinks that a term means is irrelevant. What's relevant is what the text says. So I don't think whatever Ms. Carter has to say about what she thinks the knowledge term means is relevant to whether this was followed or not.
The witness was the chief negotiator of this language on behalf of the county. I can ask it differently, but she should have foundation, if anybody does, as to what the intent and purpose of this language was.
May I respond to that quickly? Just to give some background, even if someone is a chief negotiator for their side, unless they have evidence or documentation of what both sides collectively, when they agreed to something and put in their joint contract, what their intent was, then again, it doesn't matter what Susan Carter as an individual, even if she was a chief negotiator, thinks that the language says. So that's just contract interpretation principles. Right. So again, I would just say that whatever she has to say about the meaning of this text doesn't matter.
And at this point, I'm going to overrule, but I would like you to ask it in form, if you could,
Sure.
please.
Sure. Thank you. Ms. Carter, in your experience with the service unit, how has the language related to the when a grievant becomes aware or should have become aware been applied to grievances in the past?
Can you repeat that one more time?
Yeah, so based on your experience with the service unit, how has this language in the contract been applied to grievances related to the service unit in the past?
So typically it is determined based off of one, how the grievant, who the grievant is identified in the grievance form. In this case and in others, typically the grievant is identified by SEIU, the service unit. As far as, can you repeat that last part of your comment?
What the question was, how has this been applied by the parties in this current appeal in the past? How have the parties applied this in the past?
Typically, it's applied, as I mentioned, when we receive that grievance form, then we typically, it's identified on the form who the grievance are. In this case, in this particular section, or item, the grievance were identified by Aaron Herring as first he had noticed that it was the fire department. Then he indicated the 3 fire staff that were grievance.
Okay, thank you. In your experience in dealing with grievances, has the 10 working day deadline resulted in frivolous grievances being filed?
Has the 10-day deadline resulted in frivolous? No.
And what is your understanding based on the negotiations of the 10 working day deadline, the purpose of that deadline?
So the adjustment procedure, as it identifies in the first paragraph of 0902, is that we are trying to settle these grievances at the lowest level and as promptly as possible. So the steps, the days that are required for the responses are put into place to encourage that response, that prompt response. And that it starts at the supervisor, unless the supervisor is part of the grievance, so that we can get it at the lowest level possible. So it is trying to encourage, just as the first paragraph stated, that at the lowest level of supervision, but also as promptly as possible, so that it isn't delayed, such as where we're at right now.
Okay. And so hypothetically, if an employee attempts to resolve a concern before filing a grievance, is it your understanding that this 10-day deadline for filing the written grievance is suspended or delayed?
No,
And would an attempt to informally resolve a concern before filing the grievance suspend the 10-day deadline?
no,
Is it your understanding that the steps in the grievance process are mandatory for the parties?
yes.
Okay. And what is your understanding of the purpose of these individual steps in the grievance process?
Well, as I said before, I believe the purpose of these steps is to encourage that reaching out at the lowest level to obtain an adjustment of the grievance in some manner.
Okay. And in your experience, and based on the contract language here, what happens if a grievance is submitted at the wrong step?
It's denied because it's improperly submitted.
Okay. And is that how the parties have interpreted this grievance process in the past?
It's my understanding, yes.
Okay. Thank you. You mentioned denial of the grievance. What happens when the grievance is denied?
Well, so if it was submitted at any step and it was responded, the county responds that they are denying it based on certain parameters. In this case, it would be improper filing. The grievant has the ability to respond, and we will continue to go through the steps even though we are still denying the grievance as being improper. So we would, as we've done with this case, we have gone through the steps, even though it was improperly submitted to the Department of Human Resources.
Thank you. Okay, I'd now like to have you turn to County Exhibit 5.
Okay, it's what I'm looking at is an email. It looks like Justin McComb is at the top of it, his
Yes.
signature.
Yes, that's
Okay,
the document. But I actually want you to look at the email below that.
okay.
Go ahead and take a look at that for a second.
Yes, I got
You-
it.
Do you recognize this document?
I do.
And are you the recipient of this email?
Yes, I am. I'm the only recipient.
Okay.
Excuse me, let me rephrase that. I'm the only one that it was sent to. There were a few copied, but it was sent directly to me.
Okay. And do you know who Ernesto, I'm not even going to try and pronounce that last name, but who Ernesto is?
I have never worked with him, with him, but according to his signature, he is a contract enforcement specialist. So I'm assuming he was working with SEIU and supposedly with Courtney,
Okay.
excuse me, Mr. Hawkins.
Okay. And what was your understanding of the purpose of this email?
He was submitting the standby pay group grievance that was filled out by Mr. Herring.
Okay. And is it your understanding that this is the first time that the grievance was submitted?
Yes, a written grievance, yes,
Okay. And it was submitted to you directly?
correct,
Okay. And you were in the Human Resources Department, is that correct?
correct.
Okay. So based on the fact that the grievance was first submitted to you, was it compliant with the grievance step process?
No,
Why?
because again, according to the steps, the written grievance is first submitted to the direct supervisor, unless that direct supervisor is a part of the grievance itself. And if so, then that is basically, it goes to step 2, which is the department head, I believe, or a higher level. I can't remember the exact terminology, but I can look at it if you need me to.
Okay. Do you recall at what step or under what circumstances a grievance would be submitted to the Human Resources Department?
Typically it's under situations where it's more than just a departmental jurisdiction, it's a countywide jurisdiction, so the grievance would apply to numerous employees across many bargaining units, but also there needs to be a waiver, a mutual waiver or a mutual agreement to waive the rules or steps 1 and 2.
Okay. And are you aware of whether there was a waiver that would have permitted this submission of the grievance
I'm
directly
not
to you?
aware of any, no.
Okay. Would you know if there was one?
Yes.
Okay, thank you. Do you know what the county's response ultimately was to the grievance?
We denied the grievance, one for the improper filing, but also for the untimeliness, rather.
Okay. And to your knowledge, were the grievance ever notified that the grievance was denied?
I believe so. I sent a response via email to Ernesto and I copied Miguel. I'm not 100% sure if Mr. Hawkins was on the email, but I also copied the grievance. And the only reason I really remember this is because one of the grievance emails, it bounced back to me. And so I reached out to Ernesto and asked him to please forward it on to the proper email address for that grievance.
Okay, thank you. And was the service unit ever notified that the grievance was denied?
I I believe Aaron Herring was also on that email as a CC, but even if he wasn't, Miguel Barragan was, and he is their representative from SEIU.
Okay, thank you. Before I forget at this time, I would request to move County Exhibit 5 into evidence.
My only objection is that it seems to be incomplete, and I just want to make sure that my copy is not cut off. I see an email from Ernesto on June 1st, and then there's looks like something was forwarded by Justin McComb, and that's not included. And so is that meant to be included?
No, it's not part of the exhibit.
Then I have no objection.
Okay, we'll move County Exhibit 5 into evidence.
Thank you. Okay, Ms. Carter, I'm now going to have you turn to County Exhibit 2. Let me know when you're there.
I'm there.
Okay, do you recognize this document?
Yes.
And what is this document?
This is the county's response to their group, to SEIU's group grievance that was on behalf of the SEMC workers.
Okay. And who sent this document?
I sent it.
And who did you send it to?
Again, I sent it to Ernesto, Miguel, I believe Aaron Herring, and then the 3 grievance, and I'm not sure about Mr. Hawkins.
Okay,
I don't think Mr. Hawkins came into play at that point.
okay. I don't see those, I don't see Miguel or the other individual you mentioned in addition to Aaron Herring here. So was that with an email?
That was an email, yes.
Okay, and that included this as an attachment?
Correct.
Okay, thank you. In general, what does this document state about the county's response to the grievance?
In general, it stated that it was improperly submitted. The grievance was, and that it was untimely. In a nutshell, it had some background information about the employees that were at question and their jobs, their duties. It also provided just a summary that we understood that their grievance was alleging that that we didn't meet our obligation for the standby pay that's outlined in their MOU.
Okay. Was there an admission that the county had failed to pay standby?
What was stated was that it was my understanding from the department that there was a practice in place of not paying standby, and that due to it was in lieu of receiving a truck. And so there was no admission then of non-payment of standby as far as that we did anything inappropriate.
Okay. And at the time that you had sent this, had you been able to fully investigate the issue related to standby?
Yeah. So as the steps are identified in the grievance process, the county has 10 working days to respond. And so in doing due diligence during the process, we weren't able to accomplish all of our investigations to really come up with full review of everything. So when we were able to, it was determined that it didn't meet the level of standby due to the fact that the individuals, when they had the opportunity to not answer, or they could, when they answered, they could say they couldn't do it for whatever reason, whether they were sick or if they had something going on, and that there was no disciplinary actions imposed on them because they were not technically, they weren't required to stand by. And so that was ultimately what we came came up with that, due to those findings and the length of the fact that they could call back within an hour, that length of time was also part of that, the variables that were reviewed.
Okay, so there was quite a bit of information there. And so would it be correct to say that after you sent this letter, more information came to your attention?
That's correct.
And that based on that information, you determined that there was no provision of a vehicle in lieu of standby?
Correct.
Okay. I want you to look at page 3 of this document, and specifically the emboldened and underlined text, the grievance is untimely.
I see it.
You see that? You mentioned in this text the pay stubs that the employees or grievance received. What was the reason that you brought up their pay stubs?
Excuse me. Well, if they were receiving standby, they would have been paid standby, and therefore their paychecks would have reflected the payment of standby. And to my knowledge, they did not submit any information at the time when they looked at their paychecks that they were incorrect.
Okay, thank you. So to clarify, was it your understanding that they should have known that they weren't being paid standby because of what was on their paychecks or pay stubs, I
Correct.
guess?
Correct.
Okay. And because they were receiving pay stubs, or they're claiming that in the grievance that they haven't been paid for 5 years, then if there were pay stubs 5 years ago, then they would have known about it 5 years ago?
Correct.
Okay. I'd now like to have you turn back to Union Exhibit 8. And go ahead and turn to page 25.
Okay.
And so at the top, section 14 is entitled, or I guess Article 14 is entitled Standby Compensation. Do you see that?
Yes, I do.
Okay. This language under the definition of standby discusses that standby is when an employer requires an employee to remain available for callback at any time. You see that?
Yes, I do.
Based on your negotiations of this language, what is your understanding of how the parties interpreted standby?
Well, the interpretation is that not all employees would receive standby. You would have to be required to remain available for callback at any time, and that would be something that the department head would assign to the individual. Also, the fact that the CAO is the one that ultimately approves the standby in advance, and then the appointing authority then directs.
Okay, and you said CAO, just for the record,
Sorry.
who is the CAO?
County Administrative Officer.
Okay.
Sorry, we have a lot of acronyms in HR.
I understand. We have the same in law. And so if the CAO is required to authorize standby, is it your understanding that the department head can also authorize standby?
The department head works with the CAO on whether or not budgetarily they can support it, and then they would, as long as that is approved, they would then assign their employees to standby.
Okay, so would a department head be able to authorize standby without CAO approval?
No.
Okay, thank you. And so this language refers to the term callback, and you also discussed callback. I don't see that defined under standby. Are you aware of anywhere in the MOU where callback is defined?
It's under the overtime provision.
Okay, and where is that?
I believe it's 11. Oh, it's 12, it's 13.
Section 13?
Section 13, and that's on page 23. And then it's actually in subsection E.
Okay, and how does that define callback?
When due to an emergency, the employee is required to return to work on other than his or her regularly scheduled workday.
Okay, and what does that mean?
So if it's outside of their work shift or work hours, and an employee is called back due to an emergency, called back to the work site, then they would receive callback pay.
Okay, is it your understanding that callback requires an employee to physically go somewhere?
Correct.
Okay,
It could be their work site or it could be a work location,
okay,
but
thank you.
they have to come back to a location.
Okay. Are you aware of anywhere else in the MOU where callback is defined?
No.
Okay, thank you. So based on that definition, what is your understanding of how the callback, or excuse me, the standby provision of the MOU was intended by the parties?
Objection. Again, this witness cannot speak to the intention of the parties, being the union and the county. You can speak about her perspective and what she knows, but not what the union intended, because she's not the union.
Did you have anything to respond to that?
Well, the witness did testify that she worked with the union in negotiating and in interpreting the contract language as the county's chief negotiator. And so she would, if anybody would be privy to how the parties had discussed and interpreted this language, she would be one of those individuals.
May I respond to that?
Yes, please.
So in other forums, the way that we interpret contract language and to show the parties' joint interpretation of something is to show bargaining history. So what is bargaining history? It's proposals that are passed across the table with strikeouts, with write-ins, and that shows the parties wrote a certain thing, therefore they must have interpreted a certain way. So that is a collective interpretation of what the contract means. The county or even the union by itself can't unilaterally say after the fact, this is how I interpret it, and therefore that's how the union or that's how the county interpreted it. One side can't do that and impose it on the other side. There has to be a mutual agreement. And so even if she was the chief negotiator, even if she was at the table, unless she has some evidence that shows that this is what the union also agreed, her interpretation is not relevant to what the parties agreed to. So it's improper.
I'm going to sustain your motion.
Thank you.
Based on the callback language in the MOU, how has the county applied standby in the MOU?
Based on the information here and our practice, how we have applied it is that employees, when they are assigned standby, they would receive standby. And then when they're called back, the standby will stop and they will be paid under the callback provision. However, again, when the employee is assigned to standby is when we pay them standby pay.
Okay, thank you. You previously testified that the county administrative officer, CAO's authorization is necessary for standby. So then would an employee be entitled to standby under this provision, under the contract, by simply asking their supervisor for it?
No,
Okay. Would they be entitled to standby pay if they believe their supervisor had assigned them to work standby?
not unless there was CAO approval.
Okay, thank you. There has been testimony that you specifically were involved in a meeting with the grievance in this matter and other human resources personnel related to the standby pay issue in March of 2023. Were you in such a meeting?
No,
Have you taken any steps to jog your recollection of whether you were in that meeting?
yes.
What steps were those?
Um, going through my emails, going through my scheduled meetings um, to try and figure out what that was referring to. I do not have anything, nor do I recall ever meeting with this group prior to the grievance being submitted.
Okay, thank you. There's also been testimony that the Human Resources Department authorized the grievance to put standby on their time cards for March or April, not sure which one. Did you authorize that as a
No.
member of the Human Resources Department?
No,
Okay. Are you aware of anybody in the Human Resources Department who authorized that?
no. They
Is
don't
the
have
human-
the authority.
Okay, that was my next question. So if they did authorize it, would it have been valid under the memorandum of understanding?
No.
Okay. No further questions at this time.
Let's examine.
Yes, thank you. Can you please turn to County Exhibit 2?
Okay.
And I'm looking at the second page,
Okay.
and the second paragraph that starts with Miss Diaz.
Yes.
Okay, in that first sentence, you're referring to emergency repairs outside of normal work hours.
Correct.
And am I understanding correctly that you're responding to a standby pay concern in this letter?
I was giving background as to their particular duties. I was showing that it's related to emergencies because of callback. But yes, it also has to do with standby, because standby, again, you are eligible for standby, or you're required to receive standby when you're required to be called back.
Okay, so is it your understanding that standby pay is only triggered in instances of emergencies?
No,
Okay, so what was your reference to emergencies in this paragraph?
the reference to the emergency again was that she's not expected to come back and do emergency work. She's not expected to come back and do work, but I did put in emergency.
Okay, so you're speaking more so to the requirement to respond.
Correct.
Okay, can you look at the top of this second page, first paragraph, as has been agreed upon?
Yes.
Okay, you're referencing a practice of more than 7 years of the county vehicles being provided in lieu of standby pay. Where did you learn of this agreement?
I learned of that from the department.
Who in the department?
I would say Chief McComb, as I was initially trying to gather information.
Okay, and what was your understanding of how this was applied in the department by Chief McComb or anyone else?
The information that I was given was that Chief McComb actually either he spoke with someone else in the department or he reached out to the prior chief to obtain that information, and then it was shared to me, with me.
Okay. From your knowledge, was the standby pay language in the MOU with SEIU 521, was that ever changed to reflect this in lieu
No.
agreement? Okay, so this agreement did not involve the union, is that correct?
I am not aware of whether it involved the union or not. My understanding was that it was agreed upon over 7+ years ago. And at that time, I wasn't involved and neither was Miguel Barragon. So we could not substantiate anything to do with that.
Okay, are you in your capacity as human resources manager for the county, are you familiar with the Mayor's Milius Brown Act?
Yes, I am.
Okay, is that a law that's applicable to the county?
Yes.
Okay. Do you know what and I will refer to it as the MMBA. Do you know what the MMBA says regarding direct dealing?
Objection calls for legal opinion. This is a lay witness. He is not an attorney. He is not somebody with, legal knowledge. She's testifying as a lay witness. She should not be asked for a legal opinion.
That's not a legal opinion. She's a human resources manager and should know the laws that are applicable to the county as human resources and labor relations. And this is a labor relations statute that's applicable to the county, which she would manage.
Is there a way you can rephrase the question?
In your capacity as human resources manager, was it one of your duties to know what the Mayor's Milius Brown Act says?
Yes.
Okay, and was it also your responsibility to apply that to county rules and policies?
Yes.
Okay. So from that knowledge, do you have any understanding of what direct dealing means under the MMBA?
I do understand what direct dealing means.
Okay, and based on your understanding, can you explain to the commission what direct dealing is?
Typically, it's when a department will negotiate, if you will, I'm using that term loosely, with employees directly, bypassing the union.
Okay, and from your knowledge of the MMBA, is direct dealing permissible or lawful under the MMBA?
It is not.
So if in fact there was some sort of agreement regarding in lieu of standby payment in the department, would that have constituted direct dealing with the bargaining unit members?
I have no knowledge whether there was direct dealing with the employees of that unit. I just know that there was a practice in place. I don't have any records one way or the other.
Okay, but you know that this practice was in place, is that correct?
I was told this practice was in place, yes.
Okay, and you know that this practice is not part of the union contract, correct?
That's correct.
Okay, so knowing those two things, does that fit under the definition of direct dealing as you just explained?
No.
Objection calls for legal opinion. She's asking a witness to take facts and apply it to law. That is a legal opinion. This is a classic example of a legal opinion. County would
believe
strongly object.
I believe her question was her understanding of MMB.
Well, Mr. President, I believe her question was, would that in fact be direct dealing? And that is an application of fact to law. And that is a legal opinion.
I'm asking her understanding, first of all, and lawyers are not the only ones who can make conclusions about laws. In her capacity as human resources manager, she has to understand the MMBA and apply it so that the county complies. And so she has the knowledge, she already testified to that. I just want her to answer this one question.
I'm going to sustain his motion. Give you the opportunity to ask the question differently.
Okay? From your understanding of the MMBA and as negotiator for the county at some point, is it your understanding that county representatives can negotiate changes to contract language directly with bargaining unit members?
Again, as I stated before, I do not know for fact that that is what happened.
That's not what I asked you. I asked you if in your capacity as human resources manager and your knowledge of the MMBA, is it possible for county representatives to go directly to bargaining unit members to change provisions of the contract?
Y- The only authorized personnel to negotiate on behalf of the county is the Human Resources Department, which is the chief negotiator within that department, excuse me.
Okay, so is the answer to my previous question yes or no?
Only the chief negotiator can negotiate with, for language.
Okay, and the chief negotiator negotiates those changes during contract negotiations, is that right?
Not always.
Can you turn please to Union Exhibit 8 to the overtime provision again? And that is on page 24. And please look at paragraph or subparagraph E.
I see it.
Okay. So you testified regarding this your understanding that callback compensation is only triggered when an employee is required to respond physically, I think you said, to a work location. Is that correct?
That's correct.
Okay. Was that term physically or in person, were any of those terms or similar ever negotiated into the contract?
As it is written here, that's what was negotiated.
Okay, and that does
So
not,
no.
sorry, what?
No.
Okay. Can you turn the page to page 25, standby compensation?
Okay.
And there it says when an employer requires an employee to remain available. Do you see that?
Mm-hmm.
Okay. You testified that it was your understanding that the grievance, here the 3 grievance, were not required to respond after their regular hours. Do you recall that testimony?
Mm-hmm.
Okay. And where did you get this understanding that they were not required to respond?
From the department, from
Who
Chief
in-
McComb.
Okay. Did you speak with anyone else in the department regarding this requirement for the grievance to respond after hours?
No.
You also testified that you had knowledge that the grievance were, I will use the word required, to respond within 1 hour of receiving that call, a call after hours? Do you recall that testimony?
Objection misstates the prior testimony.
Can you rephrase the question?
Um, do you have any knowledge about the grievance having to respond to after hours calls within 1 hour? And where did you get that understanding?
From Chief McComb, but also, we had, an informal meeting, which we were gathering information. And I believe one of the grievance, I can't recall who had mentioned that.
Can you be closer to the mic?
Sorry. In an informal meeting, I believe one of the grievance had mentioned that.
Okay, and so the grievance mentioned that in an informal meeting. Do you recall if that was before or after the written grievance was filed?
That was after.
Okay. And did the county ever investigate whether or not that 1 hour response time was in fact accurate?
I'm not aware. I did not do that, no.
Okay, so beyond what the grievance may have told you in this meeting, you are not aware of whether that 1 hour response time was in fact implemented?
Again, the response, all I was told was that it was 1 hour to respond, meaning to respond to the call, not necessarily to go out.
Okay, and can you explain to me why that difference is important to you or to the county? The 1 hour to respond to the call versus 1 hour to respond and go out?
To me, um, the determination of this is based off of the department and what is required for them and their operations. So I would defer to the department to respond to that question. I don't have an answer.
But you did send the grievance denial, right?
Correct.
Okay, and was one of the things that you considered this required response time after hours?
No,
Okay. So that only came up through the grievance meetings process?
that came up during further investigation.
At any point during your or the county's investigation of the union's standby grievance, was it determined that one or all of the grievance should have been provided standby pay for any of the periods that they claimed?
No.
So can you look again, the same page that should still be open? It's Union Exhibit 8, page 25, standby compensation.
Yep.
Okay, so we've been talking about approval from the county administrative officer.
Correct.
Can you clarify who that person would have been at the time that this grievance was filed?
You mean their name?
Yes.
I believe that would have been Jay Varney. Prior to him coming on board, yeah, when the grievance was filed, it was Jay Varney.
And you said that the CAO's approval was necessary based on budgetary considerations. Is that correct?
Objection misstates prior testimony.
I'm saying it.
Okay. What is your understanding of what the CAO considers when approving or not of standby?
Objection calls for speculation. This witness would not know about the mental processes and deliberations of the CAO.
It's not the mental process, it's the requirement under the contract, and she has already testified about the approval requirement. So I'm asking her to elaborate what goes into approval or not.
The witness testified to the language in the contract, which is explicit that it must be approved in advance by the CAO. It does not set forth any requirement, any criteria that have to be considered. That would apparently be up to the discretion of the CAO. But the contract itself is silent on that, and the witness has not testified that she knows what those criteria would be, because they're not in the contract.
I believe you might be making the assumption that they have not had a conversation amongst Ms. Carter and Mr. Barney.
Well, that hasn't been established, so then I would object on foundation. If there's evidence of that conversation, then the witness would have the knowledge to testify to that.
Okay, I'm going to sustain your motion.
Do you have any knowledge about who a representative of a county administrative officer can be?
Whoever they designate, whoever the CAO designates as their representative.
Okay, and that's also not defined in the contract, right?
No.
Okay. And to your knowledge, is this designation of a representative, is that usually in writing?
No.
Okay, is there some like official designation of a representative who can approve standby pay by the county administrative officer?
No.
So you testified that it is your understanding that every step of the grievance procedure is mandatory. Is that accurate?
Objection misstates prior testimony.
I'm not misstating the testimony. If we had a
Could
transcription,
you
we could-
restate your question? Because I was writing something down when you asked that.
Was it your testimony that every step of the grievance process is mandatory?
Okay. Do you still object, counsel? It's fine? Okay, then we'll move on. You may answer the question.
Yeah, they are mandatory. There is an exception to that with step one. If it is involving the immediate supervisor, then it would be waived and we wouldn't have step one. Step three is only implemented if, let me get the correct terminology.
What page are you looking on?
Page 14 of the union's, the service unit MOU.
Thank you.
Step three is when an issue is not within departmental jurisdiction, then the county and SEMC may mutually agree to waive the steps of 1 and 2.
Based on your understanding of the grievance procedure, if a county representative who would be the immediate supervisor does not agree to meet pursuant to step 1 of this grievance procedure, what happens to that grievance?
Again, they don't have to meet. it says that the grievance shall first seek an adjustment of the grievance by the immediate supervisor. They should have submitted a written grievance to the immediate supervisor. And as long as they are not in the actual, they're not party to the grievance, right? Then they are required to respond with a actual written response.
Do you know who the grievance immediate supervisor was in this case?
My understanding is it was Ryan Noel. I'm not sure if I said that correctly.
So to your knowledge, did the union ever submit a written grievance to Ryan Noel?
To my knowledge, the only written grievance was submitted to Human Resources.
Can you please look at Union Exhibit 4, page 1?
Yes, I see it.
Okay. Do
And-
you recall receiving this email correspondence?
Sorry, I didn't, wait, that's Exhibit 3. Exhibit 4 is the
Exhibit
email
4.
from Mr. Hawkins?
Yes.
Okay,
Do you recall receiving this email correspondence?
yes, I do.
Okay. The first sentence of this email references a meeting that was held today between the county, Mr. Barragan, and the members. Do you see that?
Yes, I do.
Okay, to your recollection, did you participate in that meeting that was being referenced in this email?
Yes, I did.
And who else do you recall being present at that meeting in addition to yourself?
Chief McCombs, the 3 grievance that were mentioned on the grievance form, Miguel Barragon, Aaron Herring, and then some HR staff. I believe there were 3.
At what step in the grievance process do you, as human resources manager of the county, get involved?
So again, it's typically at the 3rd step when the request is outside of departmental jurisdictions. This was submitted to HR. And as I mentioned before, even though we deny it, we still will meet with we will still go through the steps. The informal meeting that was on June 28th was outside of the grievance process. It was not part of the grievance.
And what do you mean when you say it was outside of the grievance?
It was a request by Miguel Barragon to meet informally to discuss this. And so when we sent our response of denial, we also advised him that if he still wished to meet, we would still further meet to discuss it, but that it would be outside of the grievance process. Meaning it was not part of the grievance. It was just, in a way, fact finding.
Okay, and to your knowledge, did the union ever consent or agree to that characterization of fact finding?
To fact find, no, it was agreed to as an informal meeting by Mr. Barragon.
I believe, oh, yes. Another thing. So can you look at, sorry, Union Exhibit 8, page 14 again? This is the grievance adjustment procedure, section 9.02.
Yes, I'm there.
Thank you. And then, so it says a written grievance must be filed within 10 working days. Can you explain to us, does a holiday constitute a working day?
No.
I believe I don't have any more questions for this witness on cross-examination.
You direct?
No further questions.
Joe will take questions from the commissioners. Joe, do you have any questions?
Susan, when a grievance got 10 days to file, okay, let's say that within those 10 days, he's required to bring documentation into you to
There's a-
show what the grievance is about, right? Okay, what question is, what happens if, let's say you're on day number 8, the 8th day, and the agreement comes back and says, well, you know, I'm gonna need some more information that I can give you. Were you gonna allow them more time? Because they have 10 days to file, right? You know, on the 8th day, they come back and say, well, I have some more documentation that I can show you, that I can give you. Will you be able to extend that time for additional time? And if you do, how much time do you give them?
Well, yes, and on 090300 of the adjustment procedure, or excuse me, the grievance procedures, it does say that time limits herein may be extended by mutual agreement of the parties involved. So typically, they could reach out to us and they could request. And if we believed that it was reasonable request, then we could potentially do that. There's also an option of filing a grievance and then asking to place it in abeyance until they can gather additional information. So there are options that are out there.
That's all I have.
Chris?
Hi, Miss Susan. Curious, during your tenure, on average, how many grievances would you say were filed through your office on a monthly basis?
I wouldn't even say they necessarily are filed monthly.
We had, it was brought to our attention during other testimony that the, Ashley Diaz was paid the, I don't want to get the term wrong. Give me just a second. Was it callback?
Standby.
Standby pay. She was authorized to issue or put standby pay on her time card, but then was later required to pay it back. What was the county's reasonings for requiring that repayment?
I can't answer anything regarding that. I was not part of that.
When you say you weren't part of that, you weren't part of any of that conversation surrounding.
In my role of HR manager over labor relations, again, there was no grievance filed on it. I didn't receive it as a grievance, so I was not assigned or did anything with that particular situation. It would be probably somebody at the departmental level, the Chief McComb, that you could potentially ask.
All right, thank you. No further questions.
Atwood.
Evening. Okay, a couple of questions. when you're talking about getting pay authorized in advance by the CAO or their representative. Jay Varney's a pretty busy guy. With all due respect to him and with all due respect to our mechanics, I wonder how fast county CAO would be responding to a mechanic calling and saying, can I put in for overtime or service pay? So isn't it logical that the mechanic is going to talk to his immediate supervisor and not go up the food chain?
Can they talk to their supervisor? Yes, about anything. The advance notice is really more at the departmental level, the department manager, director, that is the one that makes that determination whether they need it. And then that's part of a discussion they have with the CAO on whether they can support it.
So if I'm understanding you, mechanic or any employee talks to their immediate supervisor, in this case, Ryan, and Ryan takes it up the food chain and gets it approved, or Ryan says no. But the average employee is not going to call any higher up than their immediate supervisor, correct?
They could reach out to their director if they wanted to. It's
Oh.
again, anytime they work, we pay them. So if they are being called back and working overtime, we would pay them. But the issue of standby is more,
Is more long-term.
yes.
Okay. So I think I'm guessing it would be reasonable to assume for an employee to say, I get standby pay, and if the immediate supervisor says yes or no, that's their answer. If the immediate supervisor says, no, you don't, or yes, you do, that would be the authorization, correct? They wouldn't be expected to go up the food chain.
Whether there's an expectation, I don't know, but some employees would or could. Again, I'm not saying that they can't.
Okay, but I would be surprised if the person from the garage is going to call Jay Varney. I would be very surprised.
Again, I was referring to their department head, which
Right.
would be Chief McComb, but
Okay, and that's fair. That's what I'm trying to figure out. Okay. So then taking it one step further, they were told we've heard from other testimony, they had the service truck ability to take it home in lieu of standby pay. And they were told it was a privilege, all those things, that doesn't matter to me. They had the truck in lieu of standby pay, and I'm hearing that there was this agreement 7 years prior that was the agreed upon deal. Even though they weren't party to it, you weren't a party to it, Chief wasn't a party to it, but it was done somewhere. Am I understanding that correct?
it was a practice that had been in place.
It was past
Correct.
practice,
But
right.
it's been a practice that precedes all of us, yes.
Okay. So if I'm the employee and I'm told you get to have this truck at home in lieu of standby pay, and I take the truck, okay, that's in lieu of, but doesn't that allow me as the employee to assume I'm on standby and I'm expected to perform when I get a call, it's an emergency. I don't have the option to say, I'm watching television tonight, so I'm not going to go fix a fire engine.
And it does require an assignment of standby pay. So an assumption, I would, as all of us know,
Right. Yeah,
never assume,
yeah,
but at any point, at any time, if there was a question about it, they could have reached out to their union or they could have reached out to HR
okay,
to question it. They could have gone to Chief McComb or Chief Watson, and I don't know if they did. So
right, I don't either,
I'm not speaking that they didn't. I'm not.
right,
So if they believe that there was something amiss, they do have the options that I just laid out, or they did.
okay, and then one final. And you may not know the answer to this. They have the truck at home. They choose not to go on the call. They say, man, would they have been subject to disciplinary action because they've accepted the truck at home in lieu of standby pay?
In my understanding is they would not be subject to discipline.
Thank you. Okay, thank you.
Beverly?
Have a simple question, Susan. If they got that call back and they got in the truck and they left, they are then on overtime. Is that correct?
If they had gotten the call,
And they left in the truck, they are on overtime pay.
they're being called back. They are then following the callback provisions. So what that states is, again, that if they're paid at least 2 hours of pay. If they work more than that, then they're paid for the amount of hours that they work.
Okay, thank you.
Okay. If the CAO isn't present, say he's gone to a conference, and a department head sends him an email, calls him on the phone, whichever. Hey, I've got this possibility. I'm going to send these guys out for some overtime. Can he authorize that department head to speak on his behalf if he gives them permission to approve the overtime? Does it have to come straight from the CAO, or can he relate his opinion to the department head to give to the employees?
I'm not 100% sure that I can really speak to this, but one of the things that is in that the MOU is that it could be the CAO or their designee. So if I understood your question correctly, if the CAO tells somebody else that it's okay and that person relays it to the department head, then that is their designee.
My question was, could that department head be the designee on specific requests, not necessarily a blanket thing for the whole county?
I don't know if the CAO would do that, but again, it would be whom he decides to designate the information.
So he has the authority to pass his information along to whoever it might need to get to
Correct.
without having to do it himself
Correct.
directly. Okay. So if a supervisor, a direct supervisor of said employees, tells them something that is factually incorrect, can't be done, can't be paid by the county, what should have happened to that supervisory person?
I cannot speak to that. That's more performance issues. That is not within my role.
Is that an item that should have or could be grieved by an employee?
The grievance process talks about work assignments, physical facilities, defective equipment, or claimed violation or established rules and procedures, past practices within the MOU. Typically, when there are issues that individuals are being harassed or not given the right information or retaliated in some way, those go through a different process and they're filed under a different process, a policy that we have. So that would be looked at in a different way.
Okay. Bill, you had one more?
We heard in past testimony that the mechanics were instructed they had to respond within the hour. They shouldn't be more than a half hour from their home. They couldn't go out of county. Couldn't have alcohol. And that sounds like it's rather restrictive and a little more than just have the truck available if you feel like responding to it. And so that sounds like you're on standby. If you're told, hey, we want you to keep the truck at home, and if we need you, we call you, and it's convenient, we'd like you to go out and just keep the truck at home, and that way you don't have to come into the shop to pick up the truck. What would a reasonable county employee think if he's told, these are the restrictions, and we're giving you the truck in lieu of standby pay? I'm not asking if they were entitled to standby pay, but it sounds like they were on standby.
I, one, can't testify to what they were told. I can only advise what I have been told. The hour piece was what I was told. The others I was not. If again, there is a question on whether or not it's standby, again, this is the proper mechanism for going through the grievance. And we have gone through this. And they have the option of reaching out to their union members. They have the option of going to HR.
Commissioners.
But, okay, yeah.
If I might, I just wanted to make the observation that you will have the opportunity to ask questions of Chief McComb, Ryan, Noel, and former Chief Matt Watson.
Okay.
And so I'm
And I
not
don't-
sure this witness will be able to answer your questions.
And they will be. Thank you.
And
So,
rightly
thank
so,
you.
thank you. We are after 9 o'clock, but I'd like to finish, we're so close to finishing with Ms. Carter. I think I'd like to finish that. Do we have any other commissioners with questions? Okay, any redirect, recross?
Nothing.
Nothing? Council?
No, nothing further.
So we are done with this witness.
Yeah.
Thanks for being with us.
Thank you very much.
Thank you, Susan.
Thank you, Susan. It's good to see you.
All right, we will adjourn for the evening and reconvene tomorrow, same place, same time, with the same smile.